Ready, start. Family court held that even though a continuous separation of 2 years was not established and the ground of desertion could not be proven, the ground of mental cruelty was sufficiently established by the respondent as the appellant had leveled false allegations of fraud, dowry demand, harassment and assassinated the husband's character, full stop. Aggrieved by the decree of divorce granted by the family court in favor of the respondent husband, the appellant preferred an appeal before the High Court. Full stop. The High Court, void the impugned order, dismissed the appellant's appeal and upheld the order of the family court, thereby affirming the divorce decree. Full stop. It was held that the appellant could not substantiate her claims against the husband with regard to marrying her with a view to extract money from her parents, which had also led to dismissal of her petition seeking annulment of marriage, and thus conclusively proves that she had levied false and baseless allegation of fraud against the husband and his family members. Full stop. Further, it was held that the appellant's conduct in pestering the husband to leave his old family members and reside separately with the wife would tantamount to cruelty. Full stop. Lastly, it was also held that the wife has treated the husband with cruelty by casting aspersions on his character during the cross examination by making suggestions of an illicit relationship between the husband and his friend's wife without any specific pleadings in this regard. Full stop. Aggrieved by the impugned order dated 25/4/2018, the appellant is before us. Full stop. During the course of the proceedings in the matter before us, on 15/3/2024, learned counsel for the respondent stated that his client has remarried in the year 2019 and suggested that in view of the changed circumstances, the parties may be referred to mediation for arriving at a one-time lump sum amount which may be paid by the respondent to the appellant. Full stop. Learned counsel for the appellant was not averse to the said suggestion. Full stop. Accordingly, without prejudice to the rights and contentions of the parties, they were referred to the Supreme Court Mediation Center. Full stop. However, on 2/8/2024, we were apprised by the counsel for the parties that they have not been able to reach a settlement and hence, the matter was decided to be taken up on merits. Full stop. In the meanwhile, the respondent was also directed to pay a sum of rupees 50,000 to the appellant in pursuance of IA number 208023 of 2024 filed by the wife seeking the amount on account of expenses borne for physical attendance during the mediation proceedings. Full stop. During the contentions before us on 1/10/2024 with regard to the maintenance amount, counsel for the appellant stated that the monthly income of the respondent is more than rupees 1,30,000 per month, as he is getting about rupees 80,000 from gym where he works and rupees 50,000 from Spanco. Full stop. It was also submitted that the respondent has 2 houses in his name and also has 3 wives. Full stop. Whereas the counsel for the respondent submitted that the respondent is a daily wage laborer as he works on contract basis as electrician, and therefore, he gets a very nominal amount only for the days on which he gets work. Full stop. In pursuance of the said submissions, we had directed the parties to place all such facts on record by way of an affidavit because we found that only a meager amount of rupees 3,000 per month was awarded as maintenance in proceedings under section 125 of the Criminal Procedure Code, 1973, which had also been challenged by the respondent by way of revision, which shows that the respondent does not want to support his wife at all. Full stop.